everyone, my name is Tara Amin and I'm going to be discussing civil property rights in Australia. Specifically, the concept of the right of ownership, and to fully understand this concept, I will talk about it in terms of property rights in Australia in general to provide cultural context to this section of the law, as well as looking at some of the elements that common law countries share. We'll also look in detail at any limitations or protections that may exist, finally finishing with the concept of ownership and ownership of different types of property. It's important to note that the term property in a legal sense does not necessarily refer to the thing itself, but rather property is a description of a legal relationship with the thing. In common law systems, the concept of property is multifaceted in that property can be described as both real and personal. Real property is land and fixed structures that exist upon the land, whereas personal property is tangible or corporeal things. There is a distinction to be made between the right to ownership of tangible and intangible goods. Intangible rights are created by the law, such as the right to ownership of patents, trademarks, etc. Tangible things exist independently of the law, but the law governs the right of ownership and possession in them, including whether or not the goods can be owned at all. Property rights, as we understand them, are rights over things enforceable against all other persons. However, this right may exist in different capacities depending on the type of property. The right to ownership implicitly includes the right to use or enjoy the thing, exclude others from using the thing, and to sell or give away the thing. In terms of real property, property rights in the sense of ownership and possession differ heavily. Ownership and possession are interlinked. However, ownership only constitutes the possibility of possession, and not always because an owner has the right to sell or rent his property. Now, possession, on the other hand, does not constitute ownership nor necessarily the possibility or assumption of ownership, except in cases of adverse possession. An adverse possession is the legal title to a piece of property that acquires legal ownership based on continuous possession or occupation of the property without the permission of its previous owner. We'll discuss this in more detail shortly as a limitation to property rights. The history of property law in Australia begins with the idea of terra nullius, which in Latin means land that is legally seen as unoccupied. During the British colonization of Australia, colonizers later stated that at the moment they had purportedly imported all laws of England onto the land of Australia despite any existing inhabitants or legal system. The problem with this lies in the existence of Aboriginal and Torres Strait Islander people who had inhabited this land for generations before. And under this doctrine, they had no proprietary rights. To further evidence the lack of proprietary rights, an Act of Parliament in 1985 introduced the Queensland Coast Island Declaratory Act, which intended the annexation of all Mariam Islands to Queensland, where they would be under the sovereignty of the Crown. Evidently, this act was abolished in 1988 on the grounds of being invalid according to the Racial Discrimination Act of 1975. This case became part one of the Mabar v Queensland that started in 1988. The case continued so as to reassert the existence of the pre-existing rights and interests held by Aboriginal and Torres Strait Islander people. Indigenous Australians are recognized to have proprietary rights under what we now know in property law as native title. The case itself, Mabar v Queensland, existed in two parts. The second part was the following. The arguments made by the plaintiff's side was that the Mariam people, which are a specific group of Torres Strait Islanders, were entitled to their lands, not only as owners, but as possessors, occupiers, or as persons entitled to use and enjoy said lands. Whereas the Queensland government argued that these lands were not bound to the rights of these people because those rights did not exist, and as such cannot supersede the Crown and the law of England that became the law of Australia due to the terra nullius. The decision that was established at the end of this case was the existence of native title at common law, and it contended the rejection of terra nullius because the decision recognized the indigenous population and the pre-existing system of law and rights they had. The source of the decision was the fact that the land was occupied by them and due to the traditional connection that existed between the people and the land. Property law in every country exists in terms of priorities and limitations. Now, the priorities of property law are where rules of law and equity, including state law, have over time established what property interests take priority in that said country. For example, in Australia, the secure registered interests of the Torrens Tidal land systems and the effect of registration on the priority of registered security interests in personal property are two of the main priorities. Statutory limitations are another limitation that exists in Australian property law that results in a loss of property rights over time due to the absence of claim. A person may be held to acquire land by adverse possession as a result of statutory limitation. Now, the rightful owner of the adversely possessed property under the legislation in Australia may make a claim until a designated period of time has passed. In Australia, 12 to 15 years must pass before the claim may be barred. In terms of personal property, the right of possessor may be defended against all but the rightful owner. It's expressed in the adage, finders keepers. Statutory encroachment encompasses the idea that legislation and statutes may be put in place to take possession or ownership of certain lands from others, to encroach on another's land. In some cases, laws may encroach on a few different common law rights and freedoms, as in the case of migration laws, counterterrorism, and national security laws, as well as property rights. Now, as established, property rights and the right to ownership are regarded as fundamental in Australia and other common law jurisdictions, but they may be encroached on by legislative action, but only on one condition: that deprivation shan't be arbitrary and a reasonable compensation shall be given. Furthermore, protections against statutory encroachment exist. The Australian Constitution only protects property from one type of interference: acquisitions by Commonwealth other than on just terms. Unfortunately, no broader constitutional prohibition on the making of laws that interfere with property rights exists. Furthermore, the encroachment of real property within this, the main interferences would be with regards to the right of use of land and water. Not to count state environmental laws as concern of this, but rather the Environmental Protection and Biodiversity Conservation Act of 1999, which interferes with the right to use land, specifically access to World Heritage property and the Ramsar wetlands located in Australia. If ministries believe that the use of these lands are inconsistent with the Australian obligation in either convention, whether it be the World Heritage Convention or the Ramsar Convention, they will restrict access to these lands. Finally, the idea of right to ownership. Ownership implies the right to exclusive enjoyment of a thing, and that enjoyment can be either absolute or restricted. Absolute is the right of free and exclusive enjoyment, including the right to using, altering, disposing of, or destroying of the thing owned. Now, restricted ownership is ownership limited to some extent, which is a situation with land since it cannot be destroyed. So all land ownership is restricted in a sense. Now, when discussing the right to ownership in a nation, it is imperative to highlight a specific type of ownership, the most common. That is the ownership of land, to which there are multiple levels. Within Australian land ownership, an owner is entitled to use it in any manner they please, subject only to the following conditions which supersedes a person's free right: their obligation towards neighbours and the public, any condition which may have been imposed in the Crown grant, obligations entered into by express agreements with others, and restrictions and qualifications imposed by any legislation, which is understandable given the previously discussed existence of limitations on property rights.